As I said, I'm Shelley O'Connor. I'm the Director of Community Engagement at Hospice of Waterloo Region, and today we have two of our most excellent ACP ambassadors, our presenters, Lynn and Deb, who have both been with Hospice Waterloo's focus on advanced care planning since the very beginning.
That's me.
Maybe I'll just ask right away if people can mute their phones, and when the presentation starts, we'll ask you to turn your video off for the presentation part, but we will leave lots of opportunity for discussion at key points in the session. And if you, we're a pretty good sized group that you can either put your hand up and I will call on you, or you can put your question in the chat, and I'll make sure that Deb and Lynn are aware of your questions. I'd like to start with our land acknowledgement through Hospice. If we can just take a moment, and I'm going to read it. While we may be connecting virtually, we would like to acknowledge that Hospice of Waterloo Region is based on the ancestral and traditional territories of the Anishinaabe, the Haudenosaunee, and the Ottawa neutral people. Today, this gathering place is home to many First Nations, Métis, and Inuit people. And acknowledging them reminds us of our important connection to this land where we live, work, and learn.
That's not you, that's somebody.
As citizens, we have a responsibility for the stewardship of this land, and I invite you to join us in consideration of our collective role in the stewardship of Mother Earth and in the important process of reconciliation.
Thank you. Okay.
So I am going to again remind you to mute your phones, and I will turn it over to Lynn.
Good morning. Thank you all for coming this morning, for coming into your living room or dining room, wherever you are. So we'll start off our presentation with a PowerPoint that Shelley's going to navigate through here. And we'll give you kind of the background of what advanced care planning involves. So if you, I'll just wait until the first comes up and we can start. So this is a different time than when it's hard to believe we've been going through this for an entire year. Our presentations up until a year ago just dealt with broad spectrum. What if you become ill? What does your family need to know to help you make decisions and to make decisions on your behalf? Right now, we're in a very different time with COVID-19 being first and foremost in most of our minds. It's just something more real and something that we can put our finger on and say, what if this happens to me? That's all fine, but don't forget that other things, other health issues are still going to happen to us. And when we're talking about advanced care planning, we need to talk in general terms. I don't know where my healthcare is going to go down the road. So I don't know what kind of decisions I will be wanting to make for myself or someone else make for me. But for right now, we are all really feeling stressed about the questions of COVID-19 and what might happen to us should we develop this disease. The same answers apply if I develop cancer or if I develop COVID or if I have a stroke. What's important to me? That's what we need to focus on. So next slide, please, Shelley. We are really trying to focus on the days that we're alive. This slide sums it all up for us. We are all going to die someday. But on all the other days, we are not dying. We are alive all of those other days. And those are the days that we want to talk about here. We don't want to talk about pre-planning your funeral, about what happens to your jewelry after you're dead. We want to talk about what happens to your health and your life while you're alive. Next slide, please. So think about this. What if your partner or your parent has had a stroke and is unable to communicate with doctors? The doctors are going to come and turn to you for healthcare questions and for consents. What do you need to know about this other person who's important in your life and what they would want or not want? Next slide.
Sorry, it's stuck.
Oh.
There you go.
There we go. Okay, sorry, we missed one slide there. I think that there's two sides to this. The slide that we just talked about, what if somebody else dear to you becomes ill and can't speak for themselves? What are you going to say for them? The other hat that we have to wear is, what about me? What if I become ill and I cannot give consents for treatment? What is my loved one going to say for me? So when we talk about making decisions, being a substitute decision maker, we're talking about being a substitute decision maker for someone else and someone else being a substitute decision maker for me. So to put this all into context, before any treatment can be provided in Ontario, and that's all we're talking about here is Ontario. Ontario government pays for our healthcare, therefore they also regulate our healthcare. So all the laws are specific to Ontario. If you're looking up information, specify that you want information about Ontario. The US is different than us. British Columbia is different than us. Europe is different than us. It's Ontario that we need to focus on. So in Ontario, before any treatment can be provided to you by a healthcare provider, there must be an informed consent. An informed consent is a healthcare provider will say to you, this is what's wrong with you. This is what we can do about it. These are the expected outcomes of the treatment we are offering you. These are the alternatives to the treatment we're offering you. What do you want? What would be the treatment you would accept? Who does that informed consent come from? It comes from the patient and only the patient, if the patient is capable of giving those answers. But what if the patient is mentally incapable? What if they are unconscious? What if they have permanent dementia and will never be able to make decisions? What if they've just had surgery and are on a lot of heavy pain medications that they can't think clearly and make good decisions? Then someone has to step in and speak on that patient's behalf. And that person is called your substitute decision maker, the person who makes decisions for you when you are mentally incapable of making decisions. The only time that no consent is required is during an emergency. If your life is at stake and nobody's there to give consent for you, you will be given treatment with or without consent. Consent will be implied, and we'll deal with the fallout later, trying to get consent to continue on with treatment or not. Next slide, please. So in Ontario, to get this all into perspective, there's 2 steps to advanced care planning. The first step is to identify who your future substitute decision maker will be. And I'll go through that in a minute, letting you see who your potential substitute decision makers are. And this is the really important part. And this is what we want you to start practicing today, is having conversations about what is important to you. Talk to that person that will be making decisions for you so they know what kind of decisions to make. So technically, you will still be in the driver's seat of decisions, but it'll be through another person. That other person will be speaking up on your behalf. Next slide, please. So there's 2 to identify who your substitute decision maker is. The first one, now my background is I was a registered nurse in intensive care units. So I saw the fallout when people did or did not know ahead of time what decisions to make for their loved one. And I'll go into a couple stories about those throughout our presentation today. The one that I, as a nurse, really encourage you to do is to complete a legal power of attorney for personal care. If you do not create a power of attorney, there is someone automatically appointed for you, and we'll go into that in a moment. If you create a legal power of attorney, this is saying, I have thought about this. I think that you are my best choice for who can make decisions on my behalf if I am unable to make decisions about my care. Hopefully you've talked to that person and given them some guidelines about what decisions to make on your behalf. How you create a power of attorney is very simple. You can go to a lawyer and pay him and he'll do it all for you. Or you can just download a document from the internet. It's hard to remember the site, but if you can just Google Power of Attorney for Personal Care in Ontario, and it will send you to the ministry's website, and you'll get a 2-page document that you fill out. It tells you how to make it legal. It's perfectly legal. It is widely used in Ontario. So those are your 2 choices for making a power of attorney. So as I said, if you do not have a power of attorney appointed, there is a hierarchy that the government sets out who will make decisions for you. It's usually family. Your family is who you say it is. Not everybody has a perfect Walton family of mother, father, sister, brother that we all agree and we all get along just great and there's rosebuds and butterflies everywhere. Not everybody has that family. In fact, very few people do have that perfect family that is all united to make decisions. So think about, as we go through the list on the next slide, think about who's in your family and how it would apply to you. So if you present to a hospital and you cannot speak for yourself, as I said, consent needs to be obtained, but from the substitute decision maker by the medical team. The medical team would start at the beginning, at the very top of this list, and work down the list until they find the first person that can make those decisions on your behalf. So the first person would be a court-appointed guardian. This isn't common. If you are a court-appointed guardian for someone else, you'll know because you've spent time in a lawyer's office. This would be someone that has an adult child that's had a permanent disability and will never make decisions for themselves. They need a guardian appointed for them. There's many circumstances within families of where this would happen. But as I say, if you're it, you'll know because you've been in a lawyer's office dealing with it. The next one is an attorney for personal care, which is what we just discussed. Someone that you have selected and legally appointed as your attorney for personal care. An attorney here is not a lawyer. An attorney is someone who speaks on your behalf and will speak with your wishes to direct your personal care. The next one is also quite uncommon, a representative appointed by Consent and Capacity Board. If there's someone in your life who cannot make decisions and has never appointed someone, you can approach the Consent and Capacity Board and ask to be appointed as their representative. Again, you'll know if that's you because you've spent a lot of time with lawyers discussing it. If none of those are the legally appointed substitute decision makers. If none of those apply, then the health team will move down into the green section, which is family members. And again, as I said, your family is who you say it is, but the government has to have basic rules. And this is who the government says is your family. As we go through this, think about your own family. What if there's someone in your family that you're estranged from? If they're on this list, they are still going to be making decisions on your behalf unless you have appointed someone legally to do so. So the first one would be a spouse or partner. This one should be the easiest, but it isn't always. A spouse or partner can be someone of the same sex or opposite sex. You can be legally married or live in common law. As long as you have lived common law for 1 year or you have a child together, then you are considered legally capable of making decisions for your partner. This is a current spouse or partner. If you're separated or there's been marriage breakdown or divorce, that is no longer your spouse or partner. So that person would no longer be making decisions on your behalf unless you had legally appointed that person to be your power of attorney for personal care. So if there's a marriage breakdown, this is just one more thing you need to look at. Have I appointed my ex-spouse as attorney for personal care for me? I may still want that person making decisions. I may not. So you need to really think about all these things. If there is no spouse or partner, then it's parents and children. That everybody on this line has to come up with one answer. So think about the sandwich generation. Your parents may still be alive. You may have adult children. A child only has to be 16 years of age, which is pretty young to make decisions like this. But a child only has to be 16 years of age to make decisions on someone else's behalf about their health care. So think about, as I said, the sandwich generation. Grandparents never think their grandchildren are any more than babies. You can have 25-year-old grandchildren that you still think are 5 years old. So trying to get those grandparents and grandchildren working together to make a decision on your behalf, that can be very, very stressful. If there's a separated family and children involved, then the parent who has the right of access only, the parent who has full custody would make decisions in the parent's line. If they are not available, then the parent who only has visitation rights, right of access, they would make decisions next. If none of those apply, it goes to your siblings, all of your siblings equally. It doesn't matter if you're estranged from some of them or not. All of your siblings equally would have to come up with one voice, with one answer together. If there are none of these, then it goes to any other relative. That's aunts, uncles, cousins, in-laws, anybody who's related to you by either blood or marriage or adoption. If there is absolutely no one on this list, then the very final choice would be the healthcare team would go to the public guardian trustee, and someone would be appointed to decisions for you. This would be someone who has never laid eyes on you, has never spoken to you, knows absolutely nothing about you, but they would be appointed to make healthcare decisions on your behalf. I'll just go through a quick, to put it all into summary, I'll go through my own family and tell you what would happen, how decisions would be made if I could not speak for myself. I have a husband, we're legally married. I have appointed him power of attorney for personal care legally. I do not have children. My father is completely mentally competent. He's turning 98 next month, but totally competent. I have 3 siblings. I have 18 cousins, something like 30 or 40 nieces and nephews and great nieces and nephews. It's just huge numbers of them. I have 14 adult nieces and nephews plus great nieces and nephews that are now all adults. So that's a lot of relatives. So here's the scenario. What if my husband and I are in a car accident together? We're both unconscious and need decisions to be made. I need decisions to be made for me. Go through the list. I don't have a guardian appointed by the courts. I do have a power of attorney for personal care, but that's my husband and he's now to speak. I don't have a representative appointed by consent and capacity board. I have a spouse, again, not able to speak right now. I have a father who's almost 98, but competent, no children, and siblings and tons of other relatives. So in this case now, that would fall on my 98-year-old father to make decisions for me. And that is not what I want of him. He could certainly do it. He's capable, he's competent. I don't want him to be put in that position. So what do? Appoint an alternate. When you create a power of attorney for personal care, always appoint an alternate so that that can step in if your first choice for power of attorney is not available. How many people do you appoint? You don't want a whole committee. You just want 1 or 2 people making these decisions for you. So again, think about yourself. A lot of you will appoint your children as power of attorney or expect your children to act as your substitute decision maker. Do you have 4 children? Would they all agree? Could they all come up with one answer to the questions that the healthcare team will ask them? It's always best and most efficient if you can appoint one person to be the lead, to be the one that they can go to the others for advice and suggestions, but one person to make the decisions and be the spokesperson so that when the medical team comes to them, they can say, here's what's going on. What do you want us to do about it? Next slide, please. So we'll do a quick little poll here. Do you want to run this, Shelley?
Yeah, I'll just pause the share and I'll pull the polls up. I'm going to launch this, and if people want to take a minute, it'll show up in your screen. You can just answer it. Well, that was quick. I think the three remaining are the three of us. So I'm going to end the polling and share the results with you. And if you want to take it from here. Got a pretty expert group, I think.
Yeah, it
I
looks
think
like
so.
you've been at our sessions before, haven't you?
Okay, I'll turn it back over to you, Lynn.
Okay, so you can go on to the next slide.
There you go.
So what does your substitute decision maker do? They will make healthcare and personal care decisions for you. They will only make those decisions if you do not have the mental capacity to make decisions. And as I said, that mental capacity can be permanent, it can be temporary, but they need some help. Help these people to make the decisions. Let them know what you would have decided for these questions that you're being presented with. So they must make the decisions the way you would have made them. They must use previously expressed wishes and act in your best interest. I'll tell you a quick story about a patient I had many, many years ago, and it still, honestly, it still haunts me. We had a man in his 70s who had a massive stroke. There was no hope of recovery whatsoever for this man. He couldn't move, couldn't eat, couldn't see, couldn't hear, couldn't speak, couldn't breathe without the help of artificial machinery keeping him alive. So that's fine. That's what we do. I worked in intensive care. That was our job, was to look after people like this. So when we could see that he was not going to recover, we went to his wife and said, this is what's going on. Your husband will never recover. He will never have the quality of life that he enjoyed prior to this stroke. What would he have wanted? If he could speak right now, what would he tell us to do? Would he want this treatment? And his wife said, oh no, he would never have wanted this treatment. He always said he did not want to be kept alive artificially. So our next question is, what should we do now? We could stop treatment and allow him to pass away peacefully, or we can keep going. What would you want us to do? She is his substitute decision maker now, so she's the one speaking for him. And she said, I want you to keep going. I want you to keep him alive. And we said, why? You're telling us this is not his wishes. He did not want to be kept alive artificially. Why do you want us to do this against his wishes? And her answer was, I want him kept alive. I want my husband alive still. We all want our loved ones with us, and we all want our loved ones alive, but this is not how he wanted to live. We kept that man alive artificially against his will for 2 years. This went on for 2 years. That was his wife's choice. She did not go with his wishes at all. Then I had another couple some years later, a man who had a life-threatening illness and said that he did not want to be kept alive artificially. When his time came, that was it for him. So had a critical illness on top of his longer term illness, came to the emergency room and again was put on artificial life support. He was not going to recover either. So again, sat down with his wife and said, is this what your husband wants? And she said, oh no. We discussed it. When he became ill, he called a family meeting, told us what his wishes were, and he clearly said he does not want to be kept alive artificially. So the second question again was, why are we doing this? And his wife said, the doctor in the emergency room came to me and said, if he's going to live, he needs to be on life support. What do you want us to do? Do you want us to do everything? And she said, how could I say no? Don't keep my husband alive. It was just, I just couldn't say the words. So that's fine. We said, did he by any chance write anything down for you to make his wishes clear on paper? And she said, yes, he did. He wrote a long list of his wishes. So she went home and got it. We read through his wishes together, and it was obvious that we were going against his wishes by keeping him alive artificially. And his wife said, I want to support what he said, but I just couldn't say the words. So as we read that sheet of paper that he had written out, that is not a legal document. She still had to say the words, do not treat him anymore, allow him to die in peace. But she had his wishes right there in front of her to help her guide the decisions. It was so much easier for her. And we were then able to remove that gentleman from life support and allow his family to sit with him as he passed away peacefully. So those were the night and day differences about the substitute decision maker, the ones that work with their wishes and the ones that worked against their wishes of the patient. It just shows how important it is for the substitute decision maker to know your wishes and how important it is for you to choose someone that will honor your wishes and act in your best interest. Next slide, please, Shelley. So the kinds of decisions that you'll be called upon to make as someone else's substitute decision maker is long-term care placement. Where do we go? Where do we take mom and dad to go into long-term care placement? Which kind of home would they like to live in? Some of the healthcare decisions that you'll be asked to make are consenting or refusing. Every time you're asked to consent to something, you're offered the option. You can refuse that. The medical team is obliged to give you all the possible treatments and remedies that they can offer. It is up to the healthcare or to the substitute decision maker to decide, does my loved one want this test, procedure, surgery, or would they rather not, and go to plan B then. You may be asked about beginning or withdrawing life-prolonging measures like artificial ventilation. You will be deciding who provides medical care. Will I bring people into my home to care for my loved one in the home? Will I have my loved one go out to a facility to be cared for? You'll be talking with the healthcare professionals about making these kinds of decisions. You'll be admitting and discharging from a medical facility, like admitting to a hospital and then get through that phase and then look at moving into a longer term placement. You'll be looking at medical information with the healthcare team. Always, always, always ask questions. When you're being faced with these healthcare decisions, if you don't understand what the healthcare team is telling you and discussing with you, ask them. When we worked as nurses, we didn't learn this overnight. This wasn't my loved one lying ill in that bed, so I didn't have the emotions involved. Stop and ask questions. And if you don't understand it, ask again and just keep asking until you understand what's being told to you. You'll be looking at deciding personal assistance services. Can I have physio come in? Can I have meals come in? Can I have someone come in to bath my loved one? Those kinds of things are what you'll be deciding. Next slide, please. For you to act as a substitute decision maker, or for you to appoint someone as your substitute decision maker, there are certain legal requirements. That person must be capable. They have to be able to understand what is being proposed for treatment and interpret how this is going to work. You don't have to be a nurse or a doctor, but you just need to be able to understand what this person is offering for treatment for you. As we said before, you must be at least 16 years of age. There cannot be a court order or separation agreement prohibiting you from being with that incapable person. That would not be in their best interest to have someone that can't be near them making decisions on their behalf. But when you think back to that hierarchy that we went through a couple minutes ago, what if someone on that hierarchy is not someone that should be making decisions for you? Then get busy and appoint a legal power of attorney. Your substitute decision maker must be available. This is 2021. We're all available all the time, basically. You can be available by Skype, by Zoom, by telephone, by email. I was in Mexico some years ago when my mother became ill, and I was my father was her power of attorney. I was the alternate. My father's sitting there looking at his wife of 65 years and said, I just can't do this. I cannot make these decisions. I want to pass it down to my daughter to make decisions on my wife's behalf. So that was me. I'm in Mexico. I was available by telephone, by email. I was fully able to participate in decision-making about my mother's health care, even though I wasn't even in the same country. As a nurse, I've called people all over the world to get consents for treatment from them. You must be willing to assume the responsibility of giving or refusing treatment. So again, in that case with my mother, my father said, I just can't do this. I know I'm the power of attorney. This is my wife. I cannot make these decisions. So he passed it on to me as the alternate. So you're not going to be forced into something you don't want to do. If someone is asking you to be their substitute decision maker and you don't feel you can do it, please say so and let them appoint someone else. And when you're looking to appoint someone as your own substitute decision maker, people will say this all the time to us in these presentations. I've tried to talk to my son about this and he won't listen. Then your son is not the one that you should be appointing as your substitute decision maker. He's telling you he can't do it. Listen to him, appoint someone else who can refer to your son and get guidance from your son, but appoint someone else to be that spokesperson for you. Appoint the best person possible in your life. Next slide, please. Some of the qualities and traits of a good substitute decision maker, that person has to be willing to talk to you, to understand your wishes, values, and beliefs. That son that won't talk to you about this is not going to make a good substitute decision maker. It would be torture for him if he can't listen to you talking about it when you're well. How is he going to talk about it when he's facing a crisis in your healthcare? Do him a favor, pick someone else that will talk with you more openly. That person must be willing to interpret, honor, and follow your wishes. You don't want that wife that kept her husband alive against his will for 2 years. You want the wife that could say, I don't want to lose my husband, but this is what he wanted and I will follow his wishes. That person must be able to communicate clearly. They can't be afraid to ask questions. They have to be able to make very difficult decisions in very stressful times. They must be willing to ask questions, not be afraid to speak up and say, I don't understand what you're saying. Can you tell me what you're saying again, please? And when they're talking to your healthcare team, they must be okay making decisions on your behalf, even if their own wishes are different from yours. This is a time to be self-centered. We're always taught to think of others before ourselves. This is the time you need to think about you. You are the one that knows your wishes better than anybody. You are the expert on you. So make sure that the person you're asking to make decisions for you becomes the next best expert on you. Make your wishes known. Next slide, please. Questions here. We'll open it up for anybody that has questions for us. Have we got you all totally muddled or is it all clear to you? If you'd like to ask a question, just raise your hand and that we can see you. I see Laura and Heather. Oh, there's lots of questions. Okay, let's start with Laura. You'll just unmute, please.
So I know it's a rare scenario, but if somebody is a public guardian and trustee, what is, like, who are they? What is their professional role typically?
Shelley, I'll let you answer that.
Yeah, so that is a provincial body. The public guardian and trustee, there's different offices across the province. So I'm not exactly sure what, ours is out of Hamilton for this area. They don't just do this, they're also looking at, they will take over and be trustees for people who are at risk of elder abuse. There's a variety of functions that they have. They do investigations. They also, prior to becoming trustees, there's a bunch of different departments. Their work, it has to be somebody who's incapable in terms of the roles that we would be sending their way or working with them. When I was doing elder abuse work, I had to provide some pretty clear evidence that the person was not capable, and then work with them around the roles that they would take on. They do take over not only personal care, but property. I don't know if that helps give you a little bit better idea, Lara.
So the people fulfilling that role, are they typically lawyers? Are they nurses, social workers?
I would say they're not, they could be, but this is a government body. These are civil servants. So I can't tell you for sure what their background would be. I've worked with different ones with a broad background, so I wouldn't say they all fall into one category.
Karen Connors.
Sorry, just need to come off mute. I wondered if you, so in my role, I often see power of attorney documents, and I've seen some that are really helpfully written, and I've seen some where they don't always help. And the simplest example is probably where you have a power of attorney document where it names, say, 2 people, or sometimes even 3, and all 3 need to agree to a decision, and sometimes they don't agree. And I just wondered if you had any comments about, the jointly and severally, or building in a clause about what to do if people don't agree.
I got lots of comments on that. My first one is I admitted an elderly man one time late at night, because these things always happen late at night. It was obvious he was not going to do well, but fortunately he could still at that point speak for himself. So we said to him, what are your wishes? We went through all the options of treatment. He told us which ones he would accept, for how long, what he would not accept. So that was great. And then we said, do you have a power of attorney? Because he was reclusive, single, elderly, no children. He said, oh, he was so proud. He said, yes, I do. Here's his name and phone number. It's my oldest nephew. Great. I called this nephew who lived 2 hours away. And I said, hi, I'm calling about your Uncle Bob, and this is going on. And he said, wait a minute, who are you talking about? And I thought, God, I've called somebody in the middle of the night with the wrong number. So I told him, like, it's your Uncle Bob. And he said, oh my gosh, I haven't heard that name for 30 years. He said he left the family. He's totally reclusive. He appointed me because I'm his oldest nephew, I guess, but he never told me. So thanks, Uncle Bob, for doing that. So anyway, luckily, Uncle Bob had given us some direction, but he didn't even tell him he had appointed him as power of attorney. So your question about the numbers of people, think about the people in your family trying to plan Christmas dinner. How well does that go when you've got 4 people trying to plan Christmas dinner? Not much gets done. Appoint one of those people to organize Christmas dinner, things start to happen and goes well. That's the same thing. We don't want a committee making decisions. Most times the lawyers will appoint power of attorney, as if it's more than one person, it will be jointly and severally, which means they can all work together or they can work one at a time. So now I've got 3 children and we're saying, this is what we need to do for mom or dad. 2 of them say, yes, do this. The 3rd one says, no, don't do that. Who do we follow? That is the problem. So that they have to have it out. And until those 3 can all come to one unanimous decision, we have to continue offering all treatments for this patient until they can come up with an answer together as one person. Often what would happen in that case, one of the family members would say, okay, I'm out. I'll just leave it to the others. We're not getting along. Not all families get along. Like I said, think about estranged families, and now you're asking them to work together. It's difficult and they're stressed. So one of them will often just bow out, and we'd write up a letter saying, I, Jane Doe, agree that my brothers John and Jim Doe can make decisions on my behalf. I'm out, and sign it, and it works out well. So it really, really, really is best just to appoint one person with an alternate. And because I like to create things to worry about, I've appointed an alternate to my alternate. What if my alternate is in that car accident with me? There needs to be another one. So appoint them one at a time. You mentioned about some of the powers of attorney documents having direction. A lot of lawyers do not like writing direction in a power of attorney document because you don't know how legally binding that's going to be. If I write in my power of attorney, do not resuscitate, but I'm sitting here and I choke on a peanut, I need to be resuscitated. To have that peanut cleared from my airway is resuscitation. But I said, do not resuscitate. So you're supposed to stand there and watch me choke to death on a peanut. So that's why they don't like writing specifics in a document. When I mentioned the wife whose husband had written out his wishes, that was a guideline. That just became his voice to his wife saying, it's okay to say, do not resuscitate. But it wasn't a legal document that the doctors could say, no, no, he said don't resuscitate, so we won't resuscitate. Does that answer your question? Okay, good.
Yeah, and I just want to caution there around the DNR, the do not resuscitate, that is a consent. So that isn't something that can be written into a power of attorney document. But I think what you're referring to, Lynn, is things like, typically in the past, they've written things like, I don't want any extraordinary measures, which, what does that mean? And how do you defend that legally? So you don't have to write your wishes down, but the lawyers will encourage you, if you want to write it down, because it's back to Lynn's example, having that information, if you haven't had those conversations, at least it's a guide. It's not a legal document, but it is a guideline for people. And I just wanted to mention another resource. The Community Legal Education Ontario has set up, they worked with Judith Wall, who was a lawyer, just now retired, but a lawyer in Toronto that ran the Advocacy Center, a legal clinic for seniors. And she worked with them to create an online process for you to do your wills and powers of attorney. And CLEO, Community Legal Education Ontario, is a great resource. It's very credible. I would trust Judith Wall was involved in writing the Healthcare Consent Act, so she knows her stuff. This tool, it's called Steps to Justice. It's called Guided Pathways, and it's linked to Steps to Justice. The thing I like about the tool, we looked at it in the spring, is that it provides you, it not only walks you through the preparation of those documents, but it also provides tips and triggers, different highlights that you need to think about along the way. And at the end of it, you get a printout that they tell you how it can be used as a legal document. I would refer you there before I would refer you to the Ministry Attorney General to download the power of attorney documents, because you get a page of direction and that's it from those pieces of paper. So if you want to do your own, which is absolutely your right, I would suggest you look at that Steps to Justice, the Guided Pathways, and I will include the link afterwards. I will send it out to everybody. Got time for one more question before I hand it over to Deb.
I think Michelle Jackson, there you are.
Hi. Two things. I just wondered if you'd screen share your substitute decision maker types of decisions page. I just want to get a quick snap of it. And I'll just get my camera ready so I don't.
Michelle, I'll send you the PowerPoint afterwards. I didn't mention in the beginning, we are recording this, so you get a link to the recording, if that helps.
Okay.
But when I turn the PowerPoint back on, I can flip there if that's easier for you.
Okay, I'm just writing as I go. As I go, I absorb better that way. So I am an RN, and I've worked in the long-term care, and I love all the content, and now I'm a doula, so I want to be helping people get their power of attorneys ready. But something came to mind when you were talking about appointing jointly or separately power of attorney. As an RN, especially in long-term care, you don't often get the copy of the the power of attorney, so you're guided by what the administration gives you. A lot of times they don't even decipher that there's a jointly or separately appointment, and we are defined as only legally being able to speak to in giving medical information to the power of attorney for personal care. I guess I'm just wanting your perception of and our general awareness of when you're the RN in those situations, where are our legal responsibilities with the jointly or separately? Where are our legal responsibilities of actually seeing the paperwork, because you're going by third person sometimes work assuming the DOC, which is our director of care, or whoever fills out the paperwork, is documenting the right thing. And sometimes we're even getting substitute decision maker and the primary contact, and it not deciphered if they're actually their power of attorney or not. So that's kind of a jumbled mess in what I'm saying, but I'm just looking for you to pinpoint what that means for both the RN medical field, and then the awareness of the confusion sometimes we have in the medical field trying to do the right thing. Does that make sense?
So, yeah, so what we would do in intensive care, you take a leap of faith. Somebody comes in with that patient and says, I'm their daughter. You trust that it really is their daughter. Sometimes we've been burned. We found out, no, they're not related. And people are coming in getting information that had no business getting information. And what we did was we had a privacy code. Since the Privacy Act came in many years ago, when a patient was admitted, we gave whoever came with them a privacy code, and only people with that code got information. We started asking for a document. If somebody said they are the power of attorney, we would ask them to bring in a document showing that they are the power of attorney. We would photocopy it and keep it on the chart. That was just what our institution liked to do. And by the way, any of you are making power of attorney, do not ever give away your original copy. Make photocopies and give that to the healthcare providers, not the original. So that was how we dealt with it. We would just ask for that document. If there was no legal power of attorney created, we had to take a leap of faith and say, yes, you three are all telling me you're the children. You're all saying the same thing. So I have to trust that there isn't a fourth child out there somewhere that you're just ignoring and thinking, no, we don't want our younger sister to know anything about this. So we would ask for the family to work together and appoint one spokesperson, because I don't have time. I'm trying to look after mom in the bed here. I don't have time to talk to 4 kids on the phone. I need to be busy looking after your loved one. So
I'm just in the nature and just paying attention to the time. Legally, Michelle, the law says that you do the best you can, and then you work with what you're presented with. You will only be held accountable if you have new information that says you know who the actual substitute decision maker is, but you've worked with somebody else. That's when you get held accountable, but not you do the best, as Lynn said. So there's lots of information on that. We can talk about that again. I do want to get into the conversation, because we do find in this work, we could spend hours talking about the hierarchy. But people do have a basic understanding of the law. What seems to happen is people will create powers of attorney. Understanding that a substitute decision maker doesn't have to be a power of attorney is another piece. But where they get stuck is on, okay, so what do I talk about? What do I share with my family? What are the things they need to know? And we have with us Deb Snyder, who, as I introduced her earlier, she's going to take over and talk about the conversation. And then we are going to break into small groups or smaller groups and work through some scenarios around the role of the substitute decision maker. So I'm going to turn it over to Deb and put the PowerPoint back up.
Thanks.
Go ahead, Deb.
Hi, everyone. Okay, so we've tried to build this presentation on a framework of who, what, where, when, why, etc. The part that I'm going to do is the how, and I like to believe that that's the tough part. Anyway, the how is having a conversation with the folks that you have identified, and perhaps even the how might be, how am I going to be an effective and reflective substitute decision maker if I'm asked to play that role. So let's talk about the conversations. If we can move on to how to start.
So I figured it would be a really
okay. I'll let that roll.
Conversation. My parents were.
Do you want me to?
Yeah,
Sorry,
keep running. That's fine.
Okay.
So I figured it would be a really easy conversation. My parents were really open to it. They thought it was a good idea, and I could not get myself to start it.
It was really something that made me uneasy, and it was something that I was really uncomfortable with.
So I knew that I should have it, and somehow I think found every reason not to have it.
And I wasn't ready to think about what does it mean that my dad's going to pass away at some point, and how do we deal with that?
And I never thought that I would have to make decisions like this for my mom.
The conversation is a process. It's not a one-time thing. At least I don't see it as a one-time thing. I think it's nice to revisit periodically.
So instead of having the conversation with my family, I did end up having the conversation with several of my friends from a similar cultural background.
So finally, we went for a hike, and we were supposed to have the conversation at dinner. That didn't happen, and then we went home. We still hadn't had the conversation, and finally my dad said, I thought we were going to have a conversation. So that's how it started.
And suddenly I realized in the moment I needed to become very, very, very quiet. And my mom needed to become very, very, very loud. And I started to just listen in a very, very present way to every single thing that she had to say. And then suddenly I started to know what questions to ask. And they weren't clinical questions. It was like, at what point, Mom, do you want me to step in and help make decisions for your life? And she said to me, well, at the point at which I can't sit down and pray with you kids. And that's really poignant. That's not making a decision about a ventilator. That's not making a do not resuscitate decision. That's something very, very simple. And all I could say to her is, yes, Mom, I will do that for you.
Because I think that the human thing is to feel like, I don't want to play God. I'm not in a position to play God and make a decision about someone's life or death.
My sister and I had very different views about what we should be doing. And in our conversations, it wasn't about what I wanted or what my sister wanted. It was about what my dad wanted, and now what my mom will want for her care. What was important for my dad was that he be at home with his family. He did not want to be in the hospital while he was really ill. And it turned out that he wanted to die at home, and we were able to do that for him.
I think we really talked about the spirit of what is life to you and what does it mean. And I think my mom, the most powerful thing she said was, you just need to know to tell the care professionals who are taking care of me or him who we are when we're not in a hospital bed. And if they know that, I have no doubt that you'll be able to have a conversation with them about what is the right kind of treatment.
I wish I could have sort of looked my father in the eyes and had that conversation. But I think that what most of us end up doing is just the best we can under really, really difficult circumstances.
You know, I have a son, and then I'm going to have the other talk at some point in his life. And it's like, yeah, you're going to have these talks throughout your life that are just uncomfortable. But if everyone is aware that they have to have that talk and can talk about it, you know, it makes it easier.
I think it made us closer because we were able to talk about and emotionally deal with how we felt. That I could tell my dad, I love you, and I don't want to talk about this, but we need to talk about it. And we got to respect each other for that.
And now, knowing how comfortable my mom is, and it only came from that conversation, we're much more comfortable that it's just another stage in life, and it will be just fine.
And we're back. Am I up, Shelley?
Yep.
Okay. So by now you're all taking a deep breath and trying to imagine yourself sitting in a room with a person who's just asked you to act as their substitute decision maker, or you're sitting in a room with a friend and asking them to be yours. So how do you get the conversation started? We've taken a look at a few bubbles here just to provide a bit of a prompt. It can be simple as, I need your help with something. Or as it wasn't the case with my dad, I was thinking about what happened to fill in the blank, an old friend who had an uncomfortable, difficult death. And it made me realize that. My doctor asked me whether I'd shared my wishes with my family and my substitute decision maker. Can we talk? And I must remind everyone, certainly in this community, I'm not sure if it's substantial all across Ontario, but in most cases, your family doctor, once you've been admitted to hospital, does not have access to you or provide you with care in any way. You're admitted to hospital and you fall under the care of an internist, and this person doesn't know you. It's important that the intricacies of your life and the plans that you want for yourself and the values that you bring to the conversation are with somebody else. I was at a workshop today. I'd like to share some information, or just fill out a booklet about myself, and I'd like to share it with you. So by now, some of you are having a conversation with yourself about how difficult these talks might be. So can you think of a conversation that you've been trying to put off? It could be with a coworker, a family member, a friend. Maybe you tried it and it didn't go well, or you fear that you're not going to get it right. Are you worried that your emotions might get in the way? So I'd like to refer you to a wonderful book by Catherine Mannix, who is a palliative care physician from from Britain. Catherine makes the point that we plan for everything else in our life. So you're quite comfortable sitting down with friends, chatting about wedding plans, or talking with your spouse about planning for a trip. You plan for your estate. So why is it that we struggle with the plans that we want to make for the period of time that we classify as end of life, or more importantly, the period that we spend in health as we prepare for death? I listened to a TED talk recently that said that in a conversation, 70% of a successful conversation is listening. So one of the things that we learned in our hospice training was the acronym WAIT, W-A-I-T. It stood for Why Am I Talking? So if you are asked, or if you are in a conversation with someone about becoming their substitute decision maker, just be still, be quiet, be curious. Watch for body language, acknowledge what you're hearing, and try to clarify quietly what it is you're understanding. If you're asking someone to be your substitute decision maker, try to be mentally practiced a little bit about how they might perceive this ask. Are they going to be really honored, or are they going to be anxious? Be as specific as you can and use some of the tools that you've been introduced to today. And be sure to tell them what attributes you feel they have that led you to consider them for this role, because frankly, it's quite an honor. The things that you might need to know as a substitute decision maker is this future planning, or are you ill now? Or is there something I need to know about an imminent health challenge? Have you told anyone else in the family, or have you told the other folk in your life? Are we going to run into problems, as Lynn has pointed out, over an ICU bed? Do you have anything written down? And if you do, where is it? Where are the copies? Can we talk about a situation where the family hasn't agreed on things? And what did you do to work it out? So there's all kinds of opportunities to make this conversation fairly practical. So let's move on to Dr. Gawandi's film and see what he has to say about this. Shelley?
Go on. There you go.
These are hard conversations. I've blown them many times myself. I've not known what to do. And with this study coming out from the Mass General, where the patients had seen a palliative care physician, I realized that the gain they'd gotten was that really they'd seen 6 people who knew how to, that's the staff at the Mass General for palliative care, that they'd seen one of these 6 people who knew how to talk to them about the end of life. And so what I did was I went to those doctors and just said, I'm really bad at this. If you had to make a little list for me of what it is that I should talk about with people facing these problems, what would you put on that list? One of the doctors that I spoke to was a palliative care physician at the Dana-Farber Cancer Institute named Susan Block. And Susan encapsulated it, I thought, the best for me, at least in a way that I could use. She said that there were 4 things that she has as a little mental list in her head that she wants to talk about with a patient who's terminally ill. Number 1, do they know their prognosis? Number 2, what are their fears about what is to come? Number 3, what are their goals? What would they like to do as time runs short? And 4th, what are the trade-offs they're willing to make? How much suffering are they willing to go through for the sake of the possibility of added time? That list was really interesting to me. It was not a list asking, do you want a ventilator or do you not want a ventilator as you come to the end? Do you want your heart shocked? Do you not want your heart shocked? Her point was, if you tell me the answers to those questions, I can make a recommendation to you that says, you would not want this toward the end if these are your goals. Our misconception is that the conversation is about hard choices. Really, it's a conversation about asking people about what they want to look forward to as time runs short and what they fear the most. And the second misconception is that that arriving at what we want at the end is a kind of epiphany. Sign here, do you want hospice, do you not want hospice? It's not an epiphany, it's a process. It's a series of conversations and ups and downs as we go through a very hard series of sequence of things that happen to you as you become ill and have things come to an end.
Right. So as Dr. Gawande pointed out, this is a lengthy series of conversations, but I'd like to ask you to focus on this definition, or at least on this quote as you start the conversation, and that is that quality of life is extremely hard to define, but we know when we don't have it. And the next slide says, is from another quote that says, I'm willing to undergo almost anything as long as I can still watch football on television and eat chocolate ice cream. This is a particular favorite of mine as a quote. So these are your must-haves. These are the things that make life worth living for you. And so those are the quotes and the concepts that we'd like you to take into the next portion of our presentation, which is some small group work, where we'll take a look at some of the stories of Fred and Stephanie. And we have some 20 minutes, I think, set aside for this. So I think Shelley's plan is to divide us up into smaller groups. I'll take the lead on one group and Lynn will be on the other. And we'll have some chats about the stories that we sent to you.
Welcome back, everyone. I hope you had some good conversation. We've kept it pretty tight. We're at the 3-minute mark. So I'm just going to, we did have another poll, but I'm going to send that to you afterwards. I have put the guided pathways link in the chat, but I will also send it along with some other resources. We are having a conversation cafe, which we started earlier at the beginning of April. It's on Tuesday mornings at 10 o'clock, and it's 1 hour focused on conversation around what are your priorities, what's important to you. Again, trying to get to that. This is a hard conversation for people to get going on. We have a few experts in the room. Some becoming more expert the more we see them. So you're welcome to join us. Again, the link is on the Hospice Waterloo Region page, and I will send that link. And I'm just going to give you a couple of minutes. If people want to unmute and if they have questions or comments, Deb and I and Lynn are here. So we've got a couple more minutes. I don't know if you want to comment on the conversation you just had or if you have some more questions. Looks like maybe the conversation tired you out.
There's a hand up with Wendy.
Oh, sorry about that. Go ahead.
I just wanted to share, Charlene was just commenting in our group about, is there a video way to record things. And I'd come across a company in the US called Mideo, MIDEO, that creates a advanced care plan online. I had looked into them. I'm not sure how it would transfer to Canada, so that's the issue right now, but there is a company working on that. And I also have a friend who you could do some research into QR codes. So those little scanning codes that people have, you can create your own QR code that could list all your medical information in your phone. So if you do a little bit of research on that, if you haven't gone that route yet, it's she made her whole plan with a QR code that's on her phone that emergency people could scan. So
amazing. Yeah.
Technology to do something.
Yeah. Use it. Embrace the technology that's there.
Yeah, exactly. And just keeping in mind, as you mentioned, the US stuff is advanced directive focused. We do not have advanced directives right now in Ontario. So it's going to come, it's not going to be a piece of paper that the doctors are going to follow. That piece of paper will be a guide for your substitute decision makers, but they're looking for a person first and foremost, except in that emergency. And we really do in Ontario focus on the role of the substitute decision maker with the idea that you can write something down at 40 that is completely irrelevant to the treatment that's being proposed at 60 or at 52, or it can be completely misinterpreted without the context of your health situation at the time. So we really, the substitute decision maker focus in Ontario is to allow you to change your mind in the moment as your priorities change. Yeah. I know you're not Ken, you don't look like Ken, so, and you're muted. Okay, all right, anybody else? No? Okay, I think that's pretty good, 11:30 I've got. So thank you for joining us. This was in recognition of National Advanced Care Planning Day, which is tomorrow. So I feel confident that you are all, excuse me, prepped to at least tell one person tomorrow about having these conversations.